So Daniel, Bank of NY Mellon and Cine-UK, really interesting decision by Master Dagnall recently.
Yes, very.
Yeah, so lots and lots in it for commercial landlords and tenants, lots of interest in relation to pandemic related issues. But I thought it might be interesting for you and I particularly to chat about the rent cessor point in it. So you'll remember that's the point where the Master said that even though the landlords had in fact insured against, let's call them pandemic risks, the tenants couldn't get the benefit of that insurance through their rent cessor provisions in their leases because the leases referred to damage or destruction by insured risks, and the Master held that just meant physical damage, and pandemic risk wasn't a physical damage, and therefore the rent cessor provisions didn't kick in. So what are you thinking about that?
Well, if I was for the landlord, I'd be saying Master Dagnall was absolutely right in what he said. And I think my opening gambit, as it were, would be to say that damage just means damage. As we all know, you've got to start with the natural and ordinary meaning of the language that's used in any contractual instrument, and especially in the context of a lease of real property, damage ought to be confined to physical damage. If somebody came up to you on the number 37 bus in Clapham at an appropriate social distance, of course, and said, my property's just been damaged, you would understand them to be referring to some form of physical damage, like a fire or a broken window or something. And exactly the same should apply here. Damage in a lease just means physical damage.
Okay, you've got your landlord's hat on. I'm going to put the tenant's hat on, and I'm going to throw down a challenge to you. Surely, as lawyers, we can understand the concept of damage as extending beyond physical damage to all forms of harm, or many forms of harm. We can understand economic loss as damage, or harm to a right or interest as damage. We surely don't confine that word simply to physical matters, do we?
Well, if I give you that with my landlord's hat on, then obviously we have to go looking for some help in the rest of the clause and perhaps even the rest of the lease. And while the wording will vary in different clauses in different leases, if we take the Cine-UK lease as a sort of model example, that referred to the rent cessor clause being engaged if the property was destroyed or damaged by an insured risk. And I would say that the fact that damage is paired with destroyed there reinforces the conclusion that we're talking about physical harm to the property. Damage and destruction exist on a sort of continuum. Destruction is a totality of physical damage to the property. We can also get some help for that by looking at the circumstance in which the rent cessor clause is said, again using the Cine lease possibly as a model example, in which the rent cessor clause is said to cease to operate. The Cine lease said one of two things would have to happen. One, you'd have the effluxion of time. I think there was a long stop date of 3 years. Alternatively, if prior to that 3 years expiring, the landlord had been able to either rebuild or reinstate the premises, the rent cessor clause would stop. And what I would say is that the words rebuild and reinstate mirror the pairing of destroyed and damaged earlier on in the clause, rebuild being paired with destruction and reinstatement with damage. And this preponderance of physical language, this preponderance of language referring to physical harm, further reinforces my landlord's argument that damage means physical damage.
Well, I think you're wrong about that. I have to say, it seems to me you can perfectly sensibly talk about reinstating after non-physical damage. But anyway, I think you're in the wrong place. I think you have to start, or at least you really have to look at the definition of insured risk. This is damage by an insured risk. And in all of these leases, as is common in commercial leases, you have a long list of insured risks, and then you have an additional discretion on the part of the landlord, perhaps to be exercised reasonably, by which it can extend that list into other forms of insurable risk at its discretion. Now, if you had in that list of express insured risks, damage by pandemic risks, that is to say closure of the premises by government action, if you had that expressly set out and you looked at the rent cessor clause and you said, I'm looking for damage by an insured risk, you would know that it included damage by government action in relation to a pandemic. You would know that it could be capable of being read as including non-physical damage. And that's exactly what's happened here. It's just simply that the landlord has chosen to extend that list of insured risks to include some business interruption risks by virtue of the particular policies that it's chosen to take out and charge the tenant for. So it seems to me that it's looking too narrowly to concentrate just on the words of the rent cessor provision. you need to have a look at the lease as a whole, and certainly including the insured risks provision.
Well, it may surprise you, Joanne, here that I'm going to have to disagree with that. I'd say that, in fact, if the intention was for the lease to capture all possible insured risks, whether on a list or insured under a sort of mopping up provision, then in the language of the rent cessor clause, which really is what we have to be concerned with here, insured risk remains subsidiary to damage. The inclusion of the word damage tells us that there's a control mechanism in place. Only certain types of insured risk, namely those that destroy or damage the property, are going to engage the rent cessor clause. And the danger of putting too much emphasis on the phrase insured risk is that it renders the word damage OTOs, which is something a court's generally going to be very reluctant to do when construing a lease or any other form of contract. But secondly, I think the tenant's argument and the argument you're putting for the tenant becomes slightly circular, because it's got to be remembered that the insurance policy here would be between the landlord and the third party, an insurer, and it would be for losses suffered by the landlord. And so it would only be engaged in the event that the rent cessor clause has been activated. So the tenant's argument gets trapped in an infinite loop where the rent cessor clause is only engaged if the insurance is kicked in, but the insurance is only kicked in if the rent cessor clause has been engaged. The operation of the rent cessor clause is having to become a precondition for its own activation, which is just absurd. And the only sensible way out is to confine the operation of the rent cessor clause to physical damage, isn't it?
No, I really can't agree, and it doesn't seem to me to be absurd at all. I think you're confusing two different things. One is the definition of an insured risk, which the landlord is entitled to extend at its discretion. The other is the question whether or not the landlord has in fact actually chosen to insure against that risk, or has effectively insured against that risk. The tenant's not interested in the question whether or not the landlord has insurance to cover. It's only interested in the question whether or not it's an insured risk for the purposes of the lease, and therefore that the rent cessor provision kicks in. It doesn't seem to me to be at all absurd. On the contrary, it seems to me to be entirely consistent with commercial common sense. This is a joint enterprise or endeavour by landlord and tenant together, and the landlord is insuring the premises and the rent payable from those premises against a series of insured risks at the cost of the tenant. And it seems to me to make perfect commercial sense that there should be a consistency of approach between the choices that the landlord makes about insurance and the ability of the tenant to get a rent cessor when those risks materialise.
Well, Joanne, you refer to commercial common sense, but I would say we simply don't get there. There's no ambiguity here. The fact that something may seem a little unfair on one of the parties isn't generally going to be good enough. If we take the facts of Ireland and Britain, the tenants in that case were stuck on an infinite service charge escalator, which seemed possibly contrary to common commercial sense. But the Supreme Court said, if that's what the language means, we have to apply it in that way. And I would say the same applies here. I'd also say that the appropriate way to insure against losses for the tenant's business is by the tenant taking, caused by something like the pandemic, is by the tenant taking out a business interruption insurance policy. What we really have going on here is a group of tenants who haven't had the foresight to take out a business interruption policy, essentially trying to piggyback on the landlord's policy, which the landlord had the foresight to take out, and rewrite the lease retrospectively to that purpose. It's simply doing too much violence to the language of the lease and moving the balance of risk and reward in the lease too far in the tenant's favour to try and do so. And that's exactly why Master Dagnall said that he was not going to do so and found in the landlord's favour.
Look, I think this point about the tenant's ability to take out business interruption insurance is a complete red herring. For a start, the tenants didn't need to take out their own independent policy in relation to payment of rent because they were insuring through the landlord at their cost. And anyway, they weren't insuring all of the aspects of their business against business interruption. They were only insuring the rent aspect, or rather, the landlord was insuring its loss to its business of the tenant ceasing to pay rent in the circumstances where these insured risks materialised. I can see we're going to have to agree to disagree about this, or perhaps one day we'll swap hats and I'll argue for the landlord and you can argue for the tenant.
Well, I think we can look forward to the appeal, and I believe that Mark Wonnacott and Ben Faulkner are going to do another video on the issue of failure of consideration, which also comes out of this, so that's also something to look forward to. But until then, nice to speak to you.
Yeah, can't wait. Bye.